morning, everyone. Justices, honourable justices, distinguished guests, learned colleagues, and our friends. First of all, welcome to Kazakhstan and welcome to the AIFC and the IAC. My name is Juejun Liu. I'm an English solicitor and solicitor advocate and has been practicing English law in the UK for the last 15 years. It is my great pleasure to be moderating today's session, which is going to look at a very interesting topic, arbitral seat, and how best to choose an appropriate arbitral seat for your arbitration. But before I start, I just want to extend my heartfelt thanks to the organizers of today's event. It is hugely impressive, as I've been speaking to friends and colleagues over breaks, that this massively impressive event has been put together in a very short space of time. And looking at Chris and your wonderful team for making it happen. So thank you, and it's great to have everyone here. Today is part of the initiative on women and diversity, I think, which is a topic that's very, very close to my heart. As someone who grew up in China and has spent the last over 20 years in the UK, I witnessed firsthand the transformation when it comes to women and their role in professional business and in the law. I certainly, absolutely delighted to be part of today's panel of very, very distinguished and eminent lawyers and experts in international arbitration, who have a sort of illustrious career in their own right, each and every one of them, but they are also collectively a testament to how diverse and successful women can be in international arbitration. Before we get started, I've been asked to remind everyone that in the case of fire, the emergency exits are located in the mini atrium between blocks C3.1 and C3.2, and they're also available in the area beyond the elevators. So, on to today's topic, arbitral seat. Now, the seat of an arbitration is a very important aspect of any arbitration. It is the legal home of the arbitration, and it provides the supporting legal framework for the arbitral proceedings. The seat of an arbitration influences a number of very important aspects of the arbitration. For instance, the rights of appeal, the availability of interim relief, the extent to which local courts are able to support, supervise, and/or hinder the arbitral process. Typically, the seat of an arbitration is agreed by parties in their contracts. Under most of the institutional arbitration rules, in the absence of a party agreement, either the arbitral institution itself or the tribunal, once constituted, will decide the seat of the arbitration. It is common for parties to go for a seat which is the same as the law, the country whose law that governs the substantive contract. But it's also possible to designate a seat that's different to the governing law of the contract. It is also very common for parties to choose a seat where they think they're likely to have merits hearings later on in the proceedings. But it's also possible to choose a seat and decide to have hearings and procedural conferences taking place elsewhere for convenience. And as I was discussing with one of the panel members on our taxi on the way here, it is also possible for the parties to choose a seat which is not closely associated with the location of the arbitral institution. And we will discuss all of these issues in a moment. But with me and help me to navigate all of these considerations and how they play in practical scenarios. I'm in the company of an extremely distinguished panel who, to me, and to most of you, will probably need no introduction at all. But for those of you that are less familiar, I'm just going to go through a very quick introduction of our speakers. To my right is Saima Hanif QC. Saima is a judge in a small claims court in the AIFC court. Saima is also a barrister in London, practicing from 3 Verulam buildings. Saima specializes in commercial law with a particular focus on financial services, banking and finance disputes, and sanctions law and judicial review. She has a cross-border practice with experience having had experience in multiple jurisdictions, including Dubai, Hong Kong, Singapore, the Isle of Man, and Guernsey. Saima acts in high-profile disputes and is currently counsel in a number of FCA investigations and PRA investigations. She has been recognized by the Lawyers Hot 100, was appointed to the role of the senior decision maker in the Guernsey, and has previous experience at the London Financial Services Authority, a leading law firm, the London Financial Markets Law Committee, and the Bank of England. To her right, we have Josephine Hicks, KC, who is a justice in the small claims court, also at the AIFC court. Josephine is also a barrister in London, practicing from 7 King's Bench Walk. She specializes in all areas of commercial law with a particular focus on insurance and reinsurance, professional negligence, civil fraud, conflict of laws, and jurisdiction. She also practices in international arbitration, including energy and natural resources disputes. Josephine is recommended in Chambers and Partners and Legal 500 as a leading silk for insurance, reinsurance, commercial dispute resolution, litigation, and professional negligence. In 2021, prior to taking silk, Josephine won the Insurance Junior of the Year at the Chambers Bar Awards. To Josephine's right, we have Gunu Nukieva. Gunu is the managing partner and head of the China office at Grata International. Gunu is a Kazakhstani attorney, a CEDA accredited mediator, a legal expert at the Institute of Legislation of the Ministry of Justice of the Republic of Kazakhstan. She has more than 25 years of international experience. She's an arbitrator on multiple panels, including the IAC and the Xi'an and Weihai arbitration commissions, both in China. Gunu has contributed to Kazakhstan's legal framework extensively, drafting the country's first tax code, customs code, and amending numerous laws. She specializes in international M&A, cross-border, commercial dispute resolution, and representing the interests of Chinese state-owned enterprises, Fortune 500 companies, and major banks. She has very successfully represented her clients in high-stakes disputes against the government of Kazakhstan concerning EPC and PPP disputes. Finally, and certainly by no means least, we have Sofia Zhakdarova. Sofia is the managing partner of Sygnum law firm here in Kazakhstan. Sofia has advised in numerous international oil and gas and mining companies for over 20 years, particularly on various sub-oil use issues. She has participated in drafting various regulations related to subsurface use, M&A, commercial and tax matters. Corporate restructuring issues, including the optimization of business, are also among her key and also a key part of her practice. Sofia has been involved in several government-run lawmaking initiatives, and she has for the Republic of Kazakhstan. She has also authored a number of publications on topical legal issues and is a frequent speaker at conferences. She's also an arbitrator and expert with international arbitral institutions, including the LCIA and ICC. Now, first of all, I'm going to approach today's session as follows. I'd like to have a quick look at a brief overview of the various arbitral seats, the key ones internationally, and then look at how the arbitral institutions and courts there have dealt with issues arising from arbitration and in connection with seats. And then I'm going to move on to consider some of the practical considerations that we ought to bear in mind in advising our clients when it comes to choosing a seat for their arbitration. I want to come to Josephine first, as Josephine has been a practitioner in the UK, in England, for many, many years. And I wanted to ask her to outline and say a few words about English-seated arbitration and how that may be distinct from the practice of arbitration in some other jurisdictions. Josephine.
Thank you very much. Well, it's a pleasure to be here. Thank you for having me. As Yejun said, there are really, I think, two key aspects to choosing an arbitration seat. The first is the quality and effectiveness of the arbitral process itself. How fair, how efficient, how cost-effective is it? And the second is how the quality and effectiveness of the court's supervisory jurisdiction over the arbitral process. Justice Hanif and I both practice in England as barristers, so as counsel acting for clients in arbitrations. We both also sit as arbitrators ourselves. Justice Hanif will give an overview of the court's supervisory jurisdiction in England and how the courts facilitate and assist arbitrations in England and also enforce judgments. Awards from arbitrations. And what I'm going to do is just offer some thoughts on the first aspect, the arbitral process itself in English-seated arbitrations. One of the perceived advantages of choosing an English-seated arbitration is the quality and the independence and impartiality of the arbitral panel. And in my view, it is not just a perception, it does reflect reality. Like the IAC arbitration rules, the Arbitration Act in England requires all arbitrators to be independent and impartial. There are numerous safeguards that have been built up through legislation and case law in England to ensure the independence and impartiality of arbitrators. And so one thing I think you can be guaranteed of if you arbitrate in England is that you will get an experienced and an independent and an impartial tribunal. Like the IAC rules, arbitrators in England are required to disclose any circumstances which might give rise to reasonable doubts about their independence and impartiality, and they're required not to act if they themselves have any concerns about their independence and impartiality. That duty of disclosure to the parties is an ongoing duty. And what that means is if you've accepted an arbitral appointment and you're sitting as an arbitrator in circumstances where at the outset you didn't perceive yourself to have any circumstances which might give rise to doubts about your impartiality, you have to keep that under review. So if I subsequently accept an instruction on behalf of clients in a different matter, I have to consider carefully whether I am still able to act impartially as an arbitrator in the existing arbitration. And that's a very important facet of focusing the mind on the ability to act independently and impartially. So in my view, that duty and the fact that it is complied with in practice in English-seated arbitrations is a really key aspect that makes sure that the tribunal is a properly independent, impartial tribunal that can decide the matter fairly by reference to the merits of the dispute and no other considerations. And that duty was recently restated by the Supreme Court in England in a seminal case called Charbon Halliburton. And that very clear articulation by the Supreme Court that arbitrators are under such a duty has really refocused attention in English-seated arbitrations on that duty of disclosure and that careful consideration by arbitrators and by the parties about the independence and impartiality of the arbitrators. And that refocused attention has not only, in my view, enhanced the independence and impartiality of arbitrators, it has also, and this is relevant to the topics we're discussing today, helped to enhance diversity among arbitral appointments. And that is something which I think will continue to happen. And the reason that is that it has forced, in a good way, parties and those instructing and advising parties to think beyond a very limited, experienced and highly regarded group of arbitrators who have traditionally been called upon to arbitrate many commercial disputes in England. And they are, as I say, a very eminent panel of arbitrators, but quite a small panel. And they've acted for many parties for many years, and they've had many repeat appointments. And those arbitrators are now being required to think very carefully, and are thinking very carefully, about whether they really are able to act impartially in disputes, and whether they give the appearance of being able to act impartially when they have extensive experience themselves of the parties and of similar disputes. And that has meant that parties are beginning to look beyond a very small group of people, and they are looking to the next generation of arbitrators and a more diverse arbitral panel. And that has presented lots of very welcome opportunities for women arbitrators, for first-time arbitrators, to start to get their experience of arbitration. We heard some incredible statistics this morning and perspectives on how gender within Kazakhstan, it really is in no way a barrier, and in fact it seems that women are very much on top and have been getting the majority of arbitral appointments, which is fascinating to me. That, I'm afraid, is not at the moment the case in England. In ad hoc arbitrations and in institutional arbitrations, it is still very much the case, certainly in the areas that I practice in, commercial law, that it is a male-dominated world. But that is absolutely beginning to change, and as I say, this duty of disclosure has caused people to think beyond the traditional arbitrators that they've turned to. So I think we are starting to see in England, as well as what we've always had, which is experienced, independent and impartial tribunals, much more diverse tribunals, and I think that's very helpful for all the reasons that were discussed in the earlier session, to help bring different perspectives, different attitudes, different approaches and innovations to the way arbitrations are conducted. And that leads me really to the second point, which is I talked about the efficiency, the cost effectiveness of the arbitral process. And that is somewhere where, again, I think England can offer real advantages. And that's because arbitrators have complete flexibility over the way they conduct arbitrations under the English legislation. Of course, certain arbitral institutions have their own rules, and the arbitrations will be conducted in accordance with them. But in ad hoc arbitrations particularly, arbitrators have a complete discretion as to how they conduct their arbitrations. They're required to do so in a fair manner, but within that they can very much adapt to what the parties want to achieve from their arbitration. And there are many arbitrations now where parties are very keen on a more streamlined approach, on a more cost-effective approach, at reaching a final resolution of their dispute without delay and unnecessary expense. And in that regard, I've been involved recently in discussions with US colleagues about the differences between English-seated arbitrations and US arbitrations. And there really are some quite stark distinctions in the ability for US arbitrations to become embroiled in extremely lengthy, extremely expensive document production and witness discovery processes, which can hugely increase the expense of arbitrations. And by and large, English arbitrations will be very keen, and English arbitrators will be astute to ensure that that doesn't happen, that document production is kept within reasonable ambits, and only documents which are necessary to the determination of the dispute will be required. And similarly, witness evidence will only be required from witnesses who are genuinely able to help the arbitrators determine the issues in dispute for them. And that attitude, which very much is a prevalent attitude among English arbitrators, does help, in my view, ensure that arbitrations that have an English sheet are conducted efficiently and cost effectively. Not always the case, of course, but and I don't pretend in any way that London arbitration is perfect in that regard, but it's very much an aim of English-seated arbitrations. What I think we do have, as I said earlier, a lot to learn from the Kazakhstan judicial and legal profession, and in particular the IAC, is where it comes to gender diversity, and not only gender diversity, broader diversity among arbitral panels. As I say, it's starting to change, but I think we have a way to go in England. And I think that's what I want to say.
Fantastic. Thank you very much, Josephine. And I couldn't agree with you more. As somebody who has watched and been involved in the legal profession in England over the last 15 years, I think you are absolutely right. I think we have a way to go to catch up, or even, I think, beyond a par with our colleagues and the friends in Kazakhstan. What's been really interesting hearing your comments is that I think the two important features of English-seated arbitrations. The first is the quality, the independence, and the impartiality of our arbitrators, and secondly, the freedom and the autonomy afforded to arbitrators within the English arbitration legislation to adapt the procedure to the features and characteristics of the disputes at hand, and that's absolutely true. I want to very much highlight those aspects of not just the English courts, but the role of the courts in supporting and supervising the arbitral process. And I very much want to come to Saima and ask you to give us maybe a sort of an overview of how, using the English courts as an example, how the judicial system supports and regulates and supervises the arbitral process itself in terms of, for instance, the availability of interim relief, deciding issues on appeals and challenges, providing, most importantly, looking at potential applications at seeking recognition and enforcement of an arbitral award. Saima.
Thank you, Jejun. And can I just begin by saying it's an absolute pleasure to be here for the inaugural Women in Arbitration Day event, so thank you kindly for the invitation. So the English courts play a vital role in supporting arbitral proceedings, and I think broadly speaking, the court's role is threefold. Its principal supervisory role is to determine applications that are made with a view to aiding the arbitration proceedings. So, for example, there may be applications to preserve evidence, for instance. Another key feature of the role that the court plays is in upholding the arbitration agreement itself. So there are frequent applications to the court to prevent a party initiating proceedings in breach of the arbitration agreement, so anti-suit injunctions. And the English courts have typically been very keen to uphold the wording within the arbitral agreement, and therefore they've been willing to assist parties to issue the injunction in appropriate cases. There have been a number of cases which have come through the courts recently which have looked at asymmetric arbitration clauses, so essentially where there is a clause saying that there has to be an arbitration seat in a particular jurisdiction, but the clause may confer a power on one party at its discretion to issue proceedings elsewhere. But what the court has said is the fact that there may be an asymmetry in the jurisdiction clause does not prevent the English court from issuing an anti-suit injunction. What we've also seen is what one might term an expansion of the ASI into an anti-enforcement injunction. So there were two cases which went to the High Court very recently, one in April this year and one in August, where the party issued proceedings seeking to restrain the defendant from issuing proceedings in breach of the arbitration clause. But in addition, what they also wanted was for the court to issue an anti-enforcement injunction to essentially prevent the party from enforcing any judgment in the event that, notwithstanding the ASI, judgment was handed down by the court in the other proceedings. And the court was happy to grant that remedy and made it very clear that it saw this as, in a sense, a natural extension of the anti-suit injunction relief. And there was no sense in which the anti-enforcement injunction was somehow exceptional or unusual. So that's a further example of how the courts are willing to uphold the agreement entered into between the parties. A further example of how the ASI relief has been expanded is a recent decision of the Supreme Court in the case of UniCredit. Now, the arbitration clause in that case specified Paris as the seat of the arbitration. The governing law was the law of England and Wales. Now, the dispute that came before the English courts was whether the English court could grant an ASI, bearing in mind that it was a Paris-seated arbitration. And there was an added point that actually the Paris courts in this situation would not have been able to grant an ASI. And the court said, well, actually, this is relief that they could grant because by virtue of the fact that the governing law was a law of England and Wales, that was a sufficient nexus to enable not only the party to issue an application in the English courts for an ASI, but also for the court to grant that relief. The case was brought under an expedited procedure system, so it went to the Supreme Court very quickly. The court has yet to hand down full reasons to support its decision because there's very much a pressure for the court to issue its decision in the first instance. So we're still awaiting the full detailed reasons, but that's a further example whereby even a nexus with England and Wales may enable a party to seek relief of that nature within the English courts. The second broad category where the English court has a role in respect of arbitrations are, for example, with regard to the appointment of arbitrators. It may be that there is nothing within the contractual framework which addresses how arbitrators are to be appointed, or it may be that the framework is lacking in detail. And that's a further area where the courts are willing to step in. The third area, in many ways, from a practitioner's perspective, the area where there's been a lot of case law and it's very interesting from a jurisprudential perspective, is challenges to the award of the substantive jurisdiction of a tribunal. Well, what can you do in that case? Under the Arbitration Act, there are various mechanisms by which the award can be challenged, but they are very clearly and carefully set out. So the first sort of general challenge, which is specified in Section 67 of the Arbitration Act, specifies a series of areas where the tribunal jurisdiction may be challenged. So, for example, where the tribunal has not been constituted properly. The second area is where there has been a serious irregularity in the arbitral proceedings. And there has been a very interesting case on this recently where it was alleged that the arbitral award was tainted by fraud. And crudely speaking, it was a dispute between Nigeria and a private contractor that had obtained a contract to develop the gas exploration project. And what was said was that the private contractor had provided evidence to the tribunal which was false, and that the private contractor knew it was false. And secondly, it was said that the private contractor had bribed the Nigerian officials so that essentially, although they were participating in the arbitration, they were not participating properly and would not put forward a proper challenge to the claim as set out by the private contractor. And this case is a very rare instance where the court upheld that challenge and found that there was a serious irregularity because essentially the award had been obtained by fraud. Happily, such cases are very few and far between, and in many ways it's a unique case with a very unique set of facts. But what it does demonstrate is, in the appropriate circumstances, the court will step in. A second case, which has recently come through the court again, where it's a challenge to the award on the basis of a serious irregularity, related to the appointment of one of the arbitrators. So as Justice Higgs had very helpfully explained when she was doing her speech, arbitrators have a duty to disclose not simply at the outset, but on an ongoing basis, whether there may be any disclosures that need to be made around relationships they may have with instructing solicitors that in that case have sought to appoint the arbitrator. Now in this case, it was the case of Shell and Aeto. The court found that there was a case of apparent bias because one of the arbitrators in question had not made full disclosure around their professional relationship with the instructing firm in question. And in essence, they disclosed some of the previous cases where they had been appointed by the law firm in question, but they had not given full disclosure of the entirety of that relationship. And on that case, the court found, well, there was a serious irregularity, and again, the challenge to the award was accepted. But again, happily, such cases are few and far between. Then the final basis on which one can challenge an award is if there's been an error of law. So essentially, there has to be something that has seriously gone wrong in the proceedings before the arbitral tribunal, or somehow it has got the law wrong in the manner of the application. The final area where the courts will assist the arbitral proceedings is with regard to the enforcement of arbitral awards. The English courts are very pro-enforcement, and it'll be a rare occasion where they will interfere with the award. The rare occasions being such as where there's a serious irregularity, such as in the Nigerian case where it was found that the award had been obtained through fraud. But generally speaking, the courts are very pro-enforcement, and it's a recognition of the importance of the arbitral proceedings and the fact that they are not there. The court is there to support those proceedings. It is not there, as it were, to sit in substitution of them. And so that's an overview of the role that the English courts play.
Absolutely fantastic. Thank you very much, Soma. To me, this is a reminder, I think, to you practitioners and arbitration lawyers that we ought to look very carefully at our clients and their opponents and the contract that we're dealing with, and consider whether there are aspects of the contract or there may be features of a potential dispute between the parties that would warrant or favour a particular jurisdiction, whether it's the availability of the court's jurisdiction to assist with the appointment of arbitrators, or it is potential issues in the actual conduct of the arbitration, fraud or otherwise, or whether there are very substantive issues and which concern the roots of challenge and rights of appeal. And these are all issues that will come to be associated with a seat of arbitration. And therefore, those are all considerations that should be front and centre in our minds when we are advising clients where to go, which way to go in the choice of the seat. We've looked very extensively at the position in England, and I want to bring in Sophia, please, to give us, again, some pointers, bearing in mind, all of you are, experienced counsel and practitioners in this jurisdiction, but I think it would be useful for us to contrast the approach and positions when it comes to courts and local arbitral seats, please.
Okay, thank you. Good afternoon, everyone, and thank you for the opportunity to speak on this critical aspect of arbitration that often determines the outcome and efficiency of such of the entire process, like selecting the best arbitration seat. The choice of an arbitration seat is not merely the logical decision here. It is a strategic one that can significantly influence the course of and effectiveness of the arbitration. The seat of arbitration determines the legal framework governing arbitration, the level of judicial support you can get from the arbitration, and even the enforceability of the final award. And therefore, making the informed decision on this matter is very crucial, especially in Kazakhstan. As my distinguished colleagues just provide and will provide you with an overview of arbitration seat outside of Kazakhstan, I would like to briefly highlight what Kazakhstan has to offer, who are the key players here, and what sets them apart. And I see here in this room the law councils and arbitrators which are active in local arbitrations. So I'm welcoming you to comment, to share your experience and views on acting for the clients or as an arbitrator. So arbitration institutions in Kazakhstan are still in the development phase. So from my research, there are approximately 18 arbitration centers in the country, though it's challenging to highlight or pinpoint the exact number due to lack of the centralized source of information for all of them. So based on my modest experience among them, I would say that the most active arbitrations are Kazakhstan International Arbitration, created and led by Professor Suleimanov, YUS, and the Atamikian Arbitration Center, and today's host is the International Arbitration Center. So the others tend to be either less active, or maybe I was not involved working with them or for them, or they are created for, let's say, specific limited purposes, which I will later tell what it is about. So personally, I do recommend arbitrations depending on the specifics of client's matter and depending on what case is about and the expertise of arbitrators. So personally, I have an experience of communicating with IAC and Atamikian Arbitration. So both institutions, from my point of view, are highly regarded for the ability to serve the interests of the parties and ensuring the fair and effective arbitration process. So when choosing the arbitration seat in Kazakhstan, I would consider the main criteria I will go through, and we'll try to compare those arbitrations under certain criteria. So the legal framework and arbitration law. This is the arbitration law in Kazakhstan aligns more or less with international standards, ensuring the reliable process, let's say. In this regard, the mentioned arbitration where I've been involved with, they are on equal footing and they operate under the more or less same legal framework. Definitely the documents of arbitration, the legal framework governing the arbitration process, knowing them and considering them is a very important factor. For example, in my practice, I met with arbitrations, small arbitrations, where I could even not get the documents which those arbitrations were operating, based documents which these arbitrations were operating on. Yeah. So neutrality, impartiality, or independence is, I think, the most crucial factor in Kazakhstan. So as we know, the arbitration seats, they should be free from any perception of bias or influenced by local interests. So they should bring the confidence to both parties that the arbitration will be conducted fairly, without undue influence from anyone like government or local courts or financial groups. For example, based on my experience, I've seen so-called pocket arbitrations. For example, they were created by certain financial groups, and to consider the cases involving these financial groups, which is absolute nonsense. And from the ideal world perspective, it shouldn't be even called arbitration. So enforceability of the arbitral awards is one of the most also important considerations. For international arbitrations, as you said, it is vital that the seat is in a country which is signatory to New York Convention, to ensure that the awards will be enforced across the member states. In Kazakhstan, we have quite well-established process and track record of enforced awards, as Chris told in one of the conference, they have very good track of the enforcement of the awards. So availability of the qualified arbitrators and legal expertise, this is also very important criteria, because the chosen seat should have a strong pool of qualified arbitrators and legal experts. Access to experienced professionals who understand the nuances of arbitration is essential for efficient and smooth process. Also, I think the seat should additionally provide the supportive infrastructure, including the reputable arbitration institutions, law firms, and facilities to conduct the hearings. So comparing the list of arbitrators, for example, their geography, qualification, and experience, I would say that IAC stands out for its diversity, for the diversity and expertise of its arbitrators. So the language and culture is very important matter here as well. So the seats should be there where the language of arbitration is widely spoken, I think. And here in Kazakhstan, the cultural practices are also very important, I would say. Cost efficiency is also a very important factor. This includes not only the arbitration fees, but also the costs of legal representation, travel, accommodation, and so on. So the cost-effective seat can make the arbitration process more accessible for anyone and less burdensome for parties involved. So in Kazakhstan, the administration costs are generally quite low, but you have to look not only at the arbitration fees, but also at other costs associated with it. So, yeah, in conclusion, I want to say that selecting the best arbitration is an important decision that requires careful consideration of those several important criteria. And for example, some companies, they do differentiate arbitration seats based on the factors like presence of foreign element in the transaction or the potential value of the claim. So I know that some of my clients, for example, if they do in their contracts establish the arbitration clause for small claims, they choose some local arbitration centers, while if they have their international contracts or they have foreign element involved, they tend to have IAC at their place for dispute resolution. So this is very general. I try to identify the criteria and compare the local arbitrations, but I would welcome anyone to share their own experience after we finish this session. So thank you very much.
Thank you, Sophia. Thank you very much. I want to pick on one of the points that you made, and that is enforcement, the ease of enforcement, the availability of sort of the regime provided for under the New York Convention. I think that is, for many of us, and certainly speaking for myself, it is one of the most important issues that in our mind when we are advising clients on sort of arbitrary institutions, but more importantly, arbitral seat. And this is, this is the moment I want to come to you, Gunul, last, but certainly by no means the least, with your wealth of experience in advising Chinese clients and Kazakh clients and international clients, and your experience in dealing with international contracts, enforcement, I know, is nearly always front and center of your mind. So I would like you to give us and our audience some pointers on the practical considerations that often play up in your mind when you are advising clients on seats, please.
Thank you, Jojo.
Thank you.
Thank you for having me, Chief Justice, Chairman, Registrar. So, as we heard from my colleagues just spoken, there is no single formula to determining the most appropriate arbitration seat. And the choice depends on many factors, including the nature of contract, and as a seat of arbitration, parties usually opt to choose third country option when we are talking about huge M&A deals or infrastructural deals involving foreign components, so-called. But when we need to distinguish between seat of arbitration and arbitration institution itself. It's a different idea, but we were discussing with Jujun that in general, in our part of the world, mostly seat of arbitration is the same as a place of location of arbitration institution, including like in China or in Kazakhstan. And when selecting the arbitration institution, just summarizing what just has been said, the classic consideration includes reputation of arbitration institution, the expected duration of the proceedings in this arbitration institution, and the cost of arbitration process. But, and considering these, the most popular choices will be London arbitration, LCIA, or ICC, or maybe Stockholm SCC, and in Asia, it will be Singapore International Arbitration Center or Hong Kong International Arbitration Center. But however, in my approach, absolutely different, and my advice to my clients different from this approach slightly. I always advise the clients to consider the specific of the country where this particular arbitration award is going to be enforced. So after all, the ultimate outcome of any dispute, it's not arbitration award itself, it's an enforcement of such arbitration award. And if the enforcement is going to take place in the part of the world where the rule of law is robust, then it's totally fine with you to choose those like well-known names. But there is a critical question, I would say, in the part of the world where I operate. After obtaining the arbitral award against, for example, state-owned enterprise or against government of this particular country, is there any risk that the state court might refuse to recognize such arbitration award, or might impose some unreasonable delays in recognition? And unfortunately, the answer for both countries, I operate China a little bit better though, and Kazakhstan, the answer is yes. And while situation in many CIS regions is actually improving a lot, there is still a place for improvement over there. For instance, in Kazakhstan, there is no even a database specifying how many percentage of foreign arbitral award can be was recognized, and how many percentage of them were rejected, and if it was rejected, on the basis of which it was rejected. There is a database of our Supreme Court which specifies that 27,600 award application for recognition for enforcement of arbitral award was in Kazakhstan, and 92%, 92.4% were granted. And we always say the biggest lie in the world is statistic, right? This particular statistic does not separate foreign arbitral award and domestic arbitral award. And as a part of my PhD research in China, I was doing scrutinizing the Supreme Court database, our e-justice system, from 2011 to 2024, so it's like, I don't know, 13 years, there were 24 court decisions on recognition and enforcement of foreign arbitral awards. And only 13 out of these 24 were enforced, recognized and enforced, reflecting only 54% of recognition rate in Kazakhstan, while, for example, in China it's 56%. Oh, 86%, sorry. So out of these 24 cases, 3 cases were represented by me. It was CITEC, Chinese Arbitration Institution CITEC Awards. One of them we smoothly recognized here in Kazakhstan. The second one was granted in the first instance for wrongly overturned in the appeal instant court and resulting in 8 months delay before recognition was ultimately achieved. And in the third case, the recognition was unlawfully refused, and appealing the decision was useless, as the defendant used this time to initiate the bankruptcy proceedings on this particular case. So in my example, it's even less. So it's better, 66%, but still. Given these circumstances and the specific of the region I work, particularly China and Central Asia, I often advise selecting the seat of arbitration in the location of the defendant or the property of the defendant, or like assets of the defendant. This approach speeds up enforcement, as no recognition process is required in this case, and allows the court to take interim measures, which is really important at an early stage of arbitration proceedings, such as asset preservation. For example, if the defendant is in China, but the seat of arbitration is London or Singapore, the Chinese court will not entertain application for interim measures, and the same approach works in Kazakhstan. So you can only recognize the final arbitral award. You cannot recognize interim measures during the arbitration hearing. However, we need to be careful with the clause, say, specifying at the location of the defendant, as it might lead to parallel proceedings or complications with the counterclaim. So basically, because defendant in China, the procedure started in China, and because another defends the same for the same case, but defendant here as a counterclaim in Kazakhstan. But it's still doable. Just need to have a proper arbitration clause on that. So basically summarizing, in cases of M&A infrastructural deal, like we all know this Xi Jinping idea of One Belt, One Road policy initiated and announced here in Kazakhstan. Therefore, we have enormous amount of Chinese investors doing business in Kazakhstan, state-owned enterprises. And as a result, it's rather natural to have disputes arising from that. And then I always advise to specify IAC as a seat of arbitration based on the above mentioned criteria. But it used to be a case before April 1, because it's like from the cost efficiency, it was like not even cheap, it was free of charge. You only need to pay for arbitrators' fees. Starting effective from April 2023 by the order of Chairman and Chief Justice, we have rules. And then just to give you a little bit of idea, like for example, if we have a dispute involving legal entity and the dispute amount is $10 million US. So for all like SCC, ICC, Singapore International Arbitration Center, the arbitration fee, I'm not considering the travel expenses and so on, just arbitration fee will be something around 120,000 up to 170,000 if we have one arbitrator. If you have 3 arbitrators, it will be 300,000 up to 400,000. For contrast, like in IAC, it used to be free of charge, but starting from the contract signed after April 1st, 2023, IAC arbitration for the same case, $10 million US, will be approximately 150,000 K, which is like kind of comparable with these arbitration institutions and it even a little bit more expensive than, correct me if I'm wrong, than Singapore Arbitration Center or CITEC, where with claim amount of 10 million US dollars, your arbitration fee will be around 100,000 US dollars, up to 120,000 in Singapore Arbitration Center. However, back to the point, the most important is again enforcement, and the primary advantage of having, for example, CITEC, which is more like, it's called the International Arbitration Center, but it's still more like local Chinese arbitration center is the most well-known in China. If the respondent is a Chinese enterprise, and IAC if the respondent is in Kazakhstan, because as I said, there is no need to go through the recognition process and avoid potential delay and risk associated with that. And at the same time, you and your clients will benefit from the expertise of highly experienced, independent, and impartial international arbitrators. And I totally agree with Patricia. It's a very, I mean, it's paid the huge attention for impartiality of the arbitrators. I will be honest with you, as a panel in the arbitrators, included in a panel of arbitrators in IAC, I've never arbitrated a case in IAC. Because I always had the client approaching who used to be my clients in the cases in M&A deals or in construction deals. And the last case were approached by Chinese state-owned enterprises again. And they were saying, can you not tell them that you are our legal advisor? Before it's like, no. And the client was approaching and saying that we will appoint you and you shall not tell them that you are our legal advisor. I was like, no, it doesn't work that way in this part of the, like, it might be working that way in this part of the world, but not in IAC for sure, because mostly the same rules apply as in London. So summarizing once again, thank you for having me, and not just because of IAC having me here today, but from the practical point of view, I do recommend IAC arbitration clause as the best choice for infrastructural and M&A deals in Kazakhstan, because defendant more likely to be in Kazakhstan, and we successfully, for example, won the cases here in AFC court and IAC against the Ministry of Transportation of Republic of Kazakhstan, Ministry of Education of Republic of Kazakhstan on PPP and EPC contracts, and they were all enforced like within a month. We received the enforcement order within 3 days, and without any recognition, without any obstacles from state courts, we get our our client got their money as a winner of these cases. Thank you.
Thank you, Gunal. That was hugely informative, and I think your word of caution relating to enforcement rings very, very loudly in my ears as someone who do a lot of work both for and against Chinese entities, and your experience and war stories of difficulties with local enforcement, I think, are certainly very true in my experience. Now back to the audience. I think with my deep felt thanks to my speakers for their excellent contributions, we've laid out a range of factors that we think that you should be considering when you are advising your clients in terms of where to go for the arbitration seat. Now I very much wanted to thank my speakers, but also open it to everyone, and maybe we'll be. One or two questions, Chris? Okay.
Everyone wants to go to lunch. Yeah, and sleepy.
Question here. Thank you. A gentleman here. Mic, please.
No, it's for translators.
All right. Thank you very much. I mean, it's a very informative session. And I just want to point to Ms. Gunal here. You've pointed, I'm a corporate lawyer, so I'm in the transaction side. Whether that particular investment is public companies related or private companies related. So in this particular infrastructure, especially in Kazakhstan, where the investments are largely into the sector where the public sector is more involved into it, to what extent do you think, from the private investors' point of view, in this particular transaction could go through the Middle East, I'm from Dubai myself, into this particular part of the world and adopting the seat of that arbitration in our contract as lawyers is a safe net, other than to rely on the traditional, of course, seat of six, whether that's in UK or an ICC. So do you believe that, particularly from the private investors, which would be part of it, it's still a safe net to choose as well?
Sure. Thank you for your question. So, this is Middle East. It's indeed it's a star in arbitration, rising star. Also, it's a new institution over there. They are most popular recently, but at the same time, even though if it's a private investor, I still believe you need to consider, like in case of dispute, most likely who's going to be the defendant, like who's going to be the claimant in case of dispute. And then if there is no, if you don't need any recognition or enforcement in Kazakhstan, then it's absolutely fine. But if you need recognition and enforcement in Kazakhstan, especially as I said, like as you said, for even if it's a private investor, like for example from abroad, but whether this project involves any partners here, state-owned related, because usually for all the investment, like in my practice, I'm also a corporate lawyer, in order to implement infrastructural project here, in most of the cases, we have state involvement, at least 25% in the very beginning, in order to sign investment contract, to enjoy tax privileges, custom privileges, and to get the land for such project. And within 5 years, this state-owned enterprise need to leave this project, and then it can become a pure private project. Like for 80% or 90% of the cases where the Chinese investors involved in doing business here in Kazakhstan, they always sign investment contract. And for that scenario, in most of the cases, state-owned enterprises are involved. And if you are having any idea that it might be a case dispute, for example, for them after 5 years when they will be leaving the project, then I still recommend local arbitration institutions, because as I know, the same, you can get the access, or you can at least do ad hoc appointment of the same arbitrators, right? And then what's the point to go all the way to Dubai International Arbitration Center if you have the same arbitrators from Dubai International Center here in Astana International Arbitration Center, or the most experienced arbitrators from Europe? So, if it will be, I'm not saying that it will be definitely, but at least 47% chance that it might be difficulties on recognition of such arbitral awards. It doesn't matter whether it's London Arbitration Institution, Singapore Arbitration Institution, or Dubai Arbitration Institution. Therefore, this risk applies for any international arbitration institutions, including the one located in Dubai. Thank you. I hope.
Thank you. A second question here, please.
May I have one question? So,
yeah, sure.
Yeah, so, no, first of all, thank you so much. It's a very interesting and impressive event. My main question is, Kazakhstan is one of the biggest landlocked country in the world, as you know, the largest country and the biggest landlocked country. And the main the policy for the government is in attracting the investment. But the main obstacle and the main problem in interaction with any foreign investors, they don't have trust to the arbitration in Kazakhstan. That's the main question. Instead of the Kazakhstan, they choose London, Stockholm, or Switzerland, or Singapore, Hong Kong, and that's what we can do to promote the arbitration in Kazakhstan. How we can involve this, how we can increase this trust. That's the main question. Maybe Sophie?
Well, I think I will start. We are looking at, I think, as was said earlier this morning, the biggest success story in Kazakhstan when it comes to international arbitration. We are staring down at the IAC, which has been a phenomenal success over the last few years. And here's hoping that the profile and standing of our IAC, of our institution, is only going to grow in the coming years. And hopefully, in not very long time at all, I think people's perceptions of Kazakh arbitration are going to change fundamentally. Here's hoping. Maybe another one more.
Thomas may want to say something as chair of the IAC, but from my perspective, it's just ensuring that the message, which Jun has just given and Thomas has given, is properly promulgated around Kazakhstan, because what you have here is access to a really excellent system, really excellent arbitrators, and you've just heard about enforcement. So this is something in which everyone ought to have complete confidence. And if that message hasn't yet been properly promulgated around Kazakhstan, that seems to be the main challenge that you face.
I absolutely agree with you, Junju, on the big invitation or the temptation or the IAC being nearly without compromise when it comes to arbitrating in Kazakhstan. Not least, we're talking about the seat, not least because we are in the unique position here at the AIFC in Astana to have a second jurisdiction on Kazakh soil. We're talking about arbitrating in Kazakhstan, but there is a difference, obviously, between arbitrating in Kazakhstan and arbitrating on matters Kazakh law, Kazakh business, Kazakh international business relations in the AIFC, under the IAC rules, and supported by and supervised by the AIFC court. You have it all here at your hands. You have a modern set of rules which guarantees you flexibility which you don't have in many other international arbitration centers, large or small. You've got a fantastically swift administration. I have to do a bit of commercial for the ISA, of course. You have a fantastically swift administration to the highest international standards that you can possibly imagine. The fact that we have produced jointly with the AIFC court 3,290 cases, completed cases, judgments, arbitral awards, and all that does speak for itself. But the most important thing, and that is the perspective beyond Kazakhstan, is what do you do? I'm coming directly back to what you said earlier. What do you actually do with a judgment or an arbitral award, rather, that you want to enforce? If my experience tells me that, if you have an award from Europe, from the UK, from the United States, you still might run into discussions, difficulties as regards enforcement if you try to do that in the Kazakh courts, for whatever reasons. I'm not an expert on that. I'm speaking under your control. But it can be difficult. It can be difficult in other countries. We've tried it. We spent half a year trying to have this enforced, and somehow, in many cases, you have the impression, not in Kazakhstan, but in other countries, that they actually used your arbitral award to light a fire, and that was it. If you have an arbitral award issued under the IAC rules, we have the possibility, and we regularly do that because we have our execution judge sitting here at my left, Christopher Campbell-Holt, to obtain an execution order free of charge in 90 minutes. Not 90 days, not 90 weeks, 90 minutes. In the IFC court, we have, although we are completely and robustly independent from the Kazakh state, memoranda of understanding which are in place, which work. That was what Gunnar was referring to, which allow these execution orders to be passed into enforcement swiftly through cooperation with the Kazakh Ministry of Justice and the National Association of Bailiffs. Hence, the possibility to enforce arbitral awards in cases against the Ministry of Transport and such like. And as I said, it took a week to actually enforce that. And I can only recommend that to any party from wherever in the world who has dealings with Kazakhstan. And we've seen it, ultimately, that we have been used as an alternative to litigating in the Kazakh state courts. It's not our destination, it's not what we're out to do, but we were used, especially as we were growing and gaining speed and gaining importance, that Kazakh parties, domestic Kazakh parties, used arbitration in the IAC to obtain fair, impartial, speedy, efficient, high-quality arbitral awards, get an execution order directly from the IFC court, and enforce in Kazakhstan, I dare say, in a speedier and more efficient way in some cases than if they had gone through the normal channels of Kazakh enforcement. And I can only recommend anyone to make use of that, because we're there for that. We're one of very, very few arbitration centers, arbitral institutions in the world that find themselves in second jurisdictions in a country, but on the geographical territory of a country, but not in the legal territory of a country. So, sorry for the sales pitch, but I had to say that. Josephine triggered it, so we're jointly guilty. Thanks very much for hearing.
Thank you, Thomas, for putting the case for the AIFC court and the IAC so emphatically. In the interest of time, I'm afraid we're going to have to bring this to a close. Please join me in thanking our excellent speakers in the warm, usual way.